My name is Shanna Yankee, and I'm an attorney on Reuterware's estate planning team. While we're suffering through negative temperatures, spring is less than 2 months away. In Wisconsin, spring is wedding season, and our clients are beginning to contact us to request assistance with preparing prenuptial agreements in anticipation of the big day. Wisconsin Marital Property Law provides default rules for the ownership, management, and disposition upon divorce or death of property owned by spouses. The default rule is that all property is marital property, and each spouse owns an undivided 1/2 interest in marital property. There are 2 types of exceptions to this general rule. First, Wisconsin law establishes some exceptions to the general rule. And second, spouses may establish their own rules in a marital property agreement, also known as a prenuptial agreement or a post-nuptial agreement, depending on when it is signed. So let's dig deeper into some exceptions to the general rule that are established by Wisconsin law. A gift or inheritance is individual property, and all income from and appreciation in the value of a gift or inheritance is also individual property. On the other hand, while a personal injury settlement is individual property, except to the extent that marital property was used to pay for expenses associated with the injury or lost income as a result of the injury, the income from a personal injury settlement is marital property. There are exceptions to the general rule under Wisconsin law, but the difference between how income is classified in these 2 circumstances is important. If a spouse wants the personal injury settlement to remain individual property, he or she needs to make sure that the income derived from the settlement is not mixed with the settlement itself. Why? Well, if individual property is mixed with marital property, then the individual property is converted to marital property. That is, unless the individual and marital components of the property can be traced. In practice, tracing individual and marital components of property is nearly impossible. If spouses or soon-to-be spouses do not like the default rules, they can make their own rules in a marital property agreement. Of course, they need to understand the default rules first in order to negotiate their own rules. Wisconsin marital property law is complex, and we've just barely scratched the surface. If you have questions regarding Wisconsin marital property law or marital property agreements, please feel free to contact any attorney on Reuterware's estate planning team.